guidelines. But sometimes I'll find that I'll look through the ethics rules, and even if I find that something that I have a question about is within the rules for me to do, it just doesn't feel right to me from the perspective of a professional. And I think that's something that's important to remember, is just because I look through the rules and it says, well, you may do this or you may not, and I think, well, I mean, in this one, in my own personal world of ethics, I will not do that, versus other ones that say that you should or shall. Right, should, shall, and may. I think the should and the may are the most interesting. Like, you may or you should. It's sort of, it's very parental of the bar, right? Like, you should, but we're not making you, but you really should. So anyway, that's the most important thing to look at, are the things that we learned back in law school, the basics of that really specific language of should, shall, may. And then also just having an instinct as a professional as to what seems right, and not being afraid to go and talk to other people. If you find that there are others who can't help you, I find that the bar ethics line can sometimes be helpful. I will say that they call and they want you to have already honed in where you think the ethical issue may be. So if you're having trouble, if it just feels like it's wrong, but you can't figure out that it is wrong, that's where I encourage people to go to mentors, to go to clinic directors, to use the wisdom that we have within our professional community to try to figure out the answer or figure out what seems right. Any questions on that? I feel like if you have a question on that, you should leave now. No, I'm just kidding. I mean, you know, you're all here because you're good people, because you want to be doing this type of work in the first place. So take those good instincts, apply them to ethics, and read the rules. I'm done. Okay, thank you very much. Now, okay, so let's start with competency under 1.1. And this is something that sometimes I find minorly frightening when you actually read into the guidelines of the comments. We'll start. This might be difficult for all of you to sort of chat about this together, but we'll see how it goes. So under competence, RPC 1.1, a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So that seems like it's very limiting when you read it on its face. But what I find really interesting about this is the comments say, sorry, I'm debating whether to have you all talk amongst yourselves, but I feel like we're too small of a group for that. Is everyone like too tired to do that too, and you just want me to talk at you? Julie says yes, you don't count. You just want me to just talk at you and you promise you'll shout out things? Okay. So what I think is really interesting is that under the comments, if you flip to, I guess, page 3 of my illustrious handout, comment 2 says a lawyer need not necessarily have special training or prior experience to handle legal problems of a type with which the lawyer is unfamiliar. A newly admitted lawyer can be as competent as a practitioner with long experience. That frightens me slightly, but is what the bar says. And I think, frankly, for a legal clinic perspective, is extremely accurate, because we have a very closed case, if you will, period of time where we're working with clients. And if there is follow-up needed, there's ability to go and do that. So I'll take one of my little questions here. I practice in bankruptcy, but this clinic client has a family law issue. Can I advise on that? Would anyone like to comment on that? Julie would? Julie nodded her head.
I answered yeah.
You can advise on that. And why?
Because your paper lawyer doesn't make any issue spot. Training, they explain the basics that we presented plenty.
True. I am going to paraphrase because the microphone just watched me nodding and smiling at you. Essentially that we're having these trainings, right, which will bring people to a level of competency that is expected in a legal clinic setting. And again, I have multiple times had follow-ups with clients after clinics in terms of, okay, here's all this basic information, but you actually do have a very specific question. Sure, here's all the family law information that you need about dissolution. but you all got married in Canada prior to the U.S. I mean, whatever the specific legal issue is, don't be afraid of saying, I'm going to get back to you about that. Because I think we all learned in law school, right? It's the practice, not the perfection of law. So, or at least if you haven't, you should all internalize that now. We need to know, things change, laws change, and we need to know how to look them up, and getting back to people with a thorough answer is not only the right thing to do, probably our ethical responsibility as we look through these pages further. So on that end, the next sort of question I had is, I don't know, that sounds like the right answer. It makes sense. Does anyone feel like that's a good response to a clinic client? No one's raising their hand. So good. Guessing is one thing when you let the client know that that's what you're doing, right? You're in the clinic setting and you say, hey, in a prior family law case, I had this happen. This might apply to you, but I am not sure, so I will need to get back to you. You don't have to leave them with an entire void of information, but you do need to do the follow-up. And that's part of the issue, or part of what 1.1 brings up in terms of competency, is that you are able to find the answer. And under one, I was going to say under comment 2, it addresses that a little bit, but under comment 1, the scope of the representation is anticipated in the first place. So it does say expertise in a particular field of law may be required in some circumstances. We're not taking on asbestos litigation in half an hour with a legal clinic client, right? It is a small, narrow window of time. I think, frankly, sometimes too short of a period of time, maybe just because I'm verbose, but you know. Although I don't know if I'm an hour and a half verbose this afternoon. We'll see how far we get. And then lastly, if I don't practice in the area, am I up to date on clinic-related legal matters? And you should be in general with these trainings. Usually most clinics have someone there who works in our major topics that come up most frequently: family law, employment discrimination. So there should be somebody around if there is more of a discrete issue. But so often what's important about the work that we're doing in a clinic environment is you're honing down like the entire universe of the law that someone's coming to you with because they just have no idea where to start, into a really manageable slice that might be something that then they can represent themselves pro se, or they realize they actually don't need any type of representation or to be following through on this legal matter. So again, there's a lot of winnowing that can be done. And actually, I don't know, maybe Julie or Dominique or someone can tell me, what do we do in terms of clinic like updates for people if they've done the CLE but keeping people updated? Do we do?
We do 2 CLEs a year now, and then we provide other CLEs as they happen. And then we also, anybody who volunteers for the KCBA legal clinic or anything on the PLS has access to all of the online
Right.
resources available.
Kathleen?
You
You do what? Say again?
do research ahead of time.
Right.
I have an active women state volunteer who gets legal issue.
Right.
And so the clinic can influence that.
Right.
Specific immigration, bankruptcy, where
Right.
it requires that knowledge, we either provide a reference or we actually have on-call attorneys in those areas
Right.
to help those clients.
Right. For the sake of the camera, the response was that there are CLEs throughout the year, topics are researched ahead of time, and there are often attorneys present who either know the topic or are on call. So for instance, I've done an immigration topic before. I do not practice in the area of immigration law. I would not begin to advise on that. And I had someone on the phone who was an immigration attorney to work through that. Do people have more questions on competency? I mean, I do think if we were talking about ethics generally and competency, we could have a lot more detailed of a discussion, but for the really closed universe case that we're looking at, and the wealth of resources that are available, for the most part being somewhat up to speed on the generalities of each field that people present with at the clinic is sufficient. Questions, comments, feelings? No? Okay. Scope of representation and allocation of authority between client and lawyer. This is one I find that actually kind of comes up in the clinic setting a lot, and I think there's a fair amount of client management issues, for lack of a better term, frankly, because we're giving them so little time. People are trying to get out their whole story to you in this very short period of time, and so managing that is important, but also letting people know up front the scope of what you can handle and what you're going to be addressing, and that they can come back. I think whenever I've started out with a client at the clinic and remind them, you can call us up and come back again. This doesn't need to be a one-stop shopping, drive-through, whatever, you know what I mean? That really helps people to feel like their needs will be addressed. So under 1.2, what we mostly look at is that the lawyer has authority to take such action as impliedly authorized to carry out the representation. And what's most important in this is that under section 1.2c, a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. So for folks who might not know, the intake form for the clinic actually specifically says something to the effect of this is a limited scope of representation. So the client has ostensibly gone over that with the volunteer ahead of time. I make sure just to mention it briefly in my introduction of myself to the client, say, you know, we're here for just a very short period of time, and so I know that you've read this and understand that I'm not representing you, but I'm here to help you figure out this legal issue as best we can, et cetera, et cetera. And I find just a little setting out the landscape for people helps them a lot to feel like they know where they can go. Now yeah, go ahead, Dominique.
I'm sorry, I didn't mean to interrupt.
No, yeah.
At the Tacoma Rainbow Center clinic that we're opening, there is an opportunity to expand that scope of representation to full representation if the volunteer believes that they have the capacity and the knowledge and ability to do it. So we do have coverage for malpractice to cover that.
Whoa.
And we can do full scope if necessary and desired.
Cool. So at the Tacoma clinic only, and this is not King County, right? This is not, okay. There is the ability to expand to full representation with malpractice coverage, which is amazing, if that's what the attorney and client both want. So that obviously would be a little different. And I mean, that can always happen at the clinic in King County as well, but there's not the coverage in terms of malpractice, and that would be something that people are obviously just taking on of their own volition. I'm trying to remember what I was, I can't remember, that's all right. A couple of examples. During the consultation, the client keeps interrupting me to tell me more of the client's story and to explain how the advice that I'm giving is not, quote unquote, on track. What do I do? Anyone have a suggestion?
Maybe stop and listen, ask him to explain the issue.
Stop and listen and what?
And ask him to explain the issue again.
And ask them to explain the issue. Anyone else? Any thoughts on that? I think personally it's largely a client, I actually hate this phrase and I want a better one, and if anyone has one, that's great, a client control issue. I like to think of it more as a client maybe understanding issue. I just really find it a little bit distasteful to think of controlling my client. I'm here to help them, and that works or it doesn't. And we have, as the rule tells us under comment 7, substantial latitude to limit the representation, but I really think if people feel like they're feeling heard, or maybe you even realize that it's a very clear legal issue that you're going to be able to give them concise information on, and they just need someone to hear them and hear that they are, not just out on a limb here, that in fact they do have a pertinent issue and that there's a way that they can address it. Now, at the same time, sometimes I do find that people will, we're in the age of Google. People will have done some research, just like we all go on WebMD and decide that we have like rare parrot fever. It is communicable. I do have it. Just want to let you all know. Kidding. So people will sometimes come to you with, hey, what about this? Hey, what about that? And I think just that's why starting out with the client and saying, hey, we have this really small window of time. Sometimes what I'll even tell people is, I would love to tell you my understanding first, see how much that answers of the questions that you have, and then get to any further questions that you have. So that way, they at least can sort of take out some concerns that they had, or maybe realize something doesn't apply, or what have you. But in general, I mean, by and large, the rule tells us that that's what we are allowed to do. It has some very clear provisions, which I know we don't cover. I do criminal defense, obviously, and I know that we don't cover that. Are you guys going to do any criminal stuff in Tacoma? Any like sealing or anything like that? Okay. There's very clear consultation, very clear representation guidelines for criminal cases, but generally otherwise, it says a lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. So to me, in a clinic setting, impliedly authorized means I'm working to get this person all the information I can in the timeline that I have. And that's the scope of our authorization of representation at that point. And so in many ways, this rule is a little bit more about making sure that you do some of that client management of expectations, how about that, instead of control, to ensure that you fit within the timeline. Now, number 2, the opposing party has the kids against court order. I'll just tell the clinic client to go get them. The client has a court order, after all, and we all know as attorneys, an order is an order, that's it. What do you all think about this one? Anyone? Everyone's seen Ferris Bueller, right? I can say Bueller. Dominique, did you want to? You don't have to, it's fine.
I think that would be bad self-help.
Bad self-help? Yeah. My feeling on this one as a criminal defense attorney is that you're getting a little too into, you don't know the rest of the scope of the situation, right? If you were the family law attorney representing this person and you knew these things, et cetera, regardless, I still think you would likely get the police involved in a situation like this. So you tell the police you have a court order, that the children are supposed to be, with you. This is, and go from there. So, and by go from there, I mean stop there. that is about the scope of what you can tell someone. And the rules are very clear. We can't advise people on how to commit a crime. You can't advise them on the consequences of it. So, if some friend is talking to me and says, well, if I have some drinks and then I drive, I say, well, okay, I can't tell you whether or not you should be driving. What I can tell you is that you can be charged either as above point of weight or affected by, and give information there as to the potential outcome or the potential consequences. So, for instance, here, yes, you do have a court order, but if something has changed and you take possession of the children, that might be kidnapping. It is okay to let people know that they do need to follow as much due course, even as this may be a situation where they are supposed to have the kids and their former, presumably, partner is in violation of that. And it's incredibly frustrating, and they're probably incredibly agitated. And usually when a situation like that occurs, aside, again, this is sort of outside of the ethics, I think what helps people, or the ethical rules, I should say, what helps people the most is to sympathize with that situation and sympathize that it's incredibly unfair that they have a court order and that really they run some risk by just going and picking up the kids themselves, that things could be even worse if that is what they choose to do. And the rules do contemplate that advising people of the potential outcomes, particularly of a criminal action, is something that you can advise. I'll even tell you the section if I can find it in my non-highlighted copy here. It's just just comment 9, indicating that we can't knowingly counsel or assist a client to commit crime or fraud, but it doesn't preclude you from giving an honest opinion about the actual consequences that are likely to result. So, again, even if you don't know the actual consequences, you can say that just doesn't feel right to me and I wouldn't advise it. The clinic client keeps calling me at my office asking me for further advice even though no follow-up was needed after the clinic. Anyone have advice for that?
Did she hand out a card to the clinic? Does we have rules against that?
Quita St. John is like the easiest name in the entire world to Google. If I introduce you and myself and say Quita St. John and someone were to Google me, they could find my number to my office very easily. So even if I don't hand out my card, somebody could very easily find me, right? So let's say you didn't hand out your card, you didn't do anything, and this person is calling. What might you do?
Drinks and dinner.
Drinks and dinner. Okay, there's one option. Don't forget I said no sleeping with your clients, so you got to stop there. Kathleen.
I think just say clearly that I'm not your attorney, so really what time will you like to test me and try to not go further. If that doesn't work, maybe, pass on to you.
Yeah, Kathleen just said to tell them kindly, I'm not your attorney, and if sort of reminding them of the scope of representation doesn't work, maybe see if someone from QLAW could call them. Dominique, what were you gonna?
Well, you can also refer them to other legal aid sources, such as the Clear Line. We also have a WebEx where you can, there are volunteer attorneys on the internet that are volunteering to provide pro bono services. So you can get a general referral as well, so you're just not leaving them without any other option as well.
Right. So what Dominique said is that there's also other options beyond just the legal clinics, that there's the Clear Line, there's a bunch of other potential, either whether it's pro bono representation or legal pro se assistance that are available. On a totally other end of this, it's hard, right? I mean, I have to tell you all, some of the most tragic stories that I have heard, and I work in criminal defense, are people who come in particularly with employment issues. I just think people are so terrible and mean to each other, and especially some of the trans clients that we've had. I would love to scoop them up and represent them completely on a case. I don't do employment discrimination. So I think just reminding yourself when you have those moments of like, I would love to spend the rest of the next 5 hours of my time with you working out this issue, that unfortunately it's not what the clinic is for, and helping to get people the best assistance that we can is what is the best that we can do, and that it's okay to limit your scope of representation. I have a sense you're all slightly bleeding hearts like I am, and you just want to take in all of them. I got a bigger car for that purpose. I can put every client in the trunk in a good, non-criminal way. And, but that again, other resources might actually be better for that person.
As a follow-up,
Yeah.
I'm sorry to say, Joe. What about if this actually happened to me? I don't know how they got my name, but I lived on Capitol Hill. I mentioned probably who I was. They call up and they say, we do want to hire you. We do have money.
Yeah.
Then what happens? I mean, you've already told them we can't represent them.
Sure.
And I certainly don't want representation of somebody who prowls QLAW clinics controlling clients. That's not what I'm all about.
It's not a terrible client base. So the question, so we have it on the recorded, is if someone follows up with you and says, hey, I can pay your fees, I want to hire you. So this is actually a clinic rule that I'm trying to remember now. So in Tacoma, it sounds like that will be possible, or will it only be if it's pro bono? Yeah.
You cannot self-refer to yourself. So you can
No, not self-referred. In this case, the client called that person afterwards and said, I want to hire you.
I think if you met them in a clinic setting and that was the scope, and you limited your scope of representation at the time you met them, then I think it probably would be a little bit more gray as to accepting that client because you met them in the clinic setting and you didn't otherwise have the idea that you were going to represent them further. I mean, you could have done that, and we have other options. But to accept fees in that change scenario, I think you would probably...
So wait, let me just to be clear so we know. So in the Tacoma setting, what I'm hearing from you is that maybe it's not in the rules, but it feels icky, is the sense I'm getting from Dominique, which goes back to my initial point about ethics, which is that that you are not to refer to yourself, but in this scenario, if a client were to come and approach you, that it might be okay if it were pro bono. Is that true, Dominique? I know Dominique's being inquired about. If it's pro bono, it might be okay.
Yeah,
but that fees, because you're not supposed to self-refer?
That's right.
Okay.
It is a shakier area, and I think that if you're using the clinic setting to take advantage of meeting the clients, that is expressly prohibited.
Right. Let me repeat that. If you're using the clinic setting to take advantage of finding clients, that is expressly prohibited. However, in this case, a client calls you and maybe you want to take it pro bono.
I think that'd be okay if you did it on a pro bono basis, but not for fee.
Okay, pro bono basis, not for fee. And that's the rule for King County as well. Now, I thought that there had been a change and now we can actually make outside referrals though, at least in King County. Is that right or not? Still a little gray? Okay, because what used to be, sorry, we can't refer you to anybody at all whatsoever, which I know is really frustrating for clients who are like, I just came to a clinic that's trained on either LGBTQ law and or how to work with LGBTQ folks. What do you mean you're just going to throw me to the wolves of every employment attorney I ever look up to call? So I know that we had been encouraging folks to look through things like Q Law memberships or the GSBA business guide or things like that for attorneys. Did you? Yeah.
So speaking from volunteer legal services, if it's a situation where a client inquires about paying an attorney, whom perhaps they made initial contact in a clinic, we deem that as acceptable.
Okay.
It's just that the attorney, as you've stated, they can't solicit paid work in a clinic setting. But if they accept a paying client outside of the clinic, they have to use their own malpractice insurance, as opposed to taking on a client pro bono. We will be able to cover them with our malpractice.
Okay, so volunteer legal, so here's, I almost feel like we need like a flow chart of this, of like, if this, then yes, if this, then no. So you approach client, that's just a no. We'll just slough that off to this territory over here. If the client approaches you and you want to take on the representation, yes, and pay a fee, and they're paying you a fee, it's your own malpractice, versus if you take it on pro bono, it's going to be the malpractice of the volunteer legal services. Awesome. Does that seem clear?
I'll tell you what I did. I did for what I call pro bono plus costs. He wanted to write his own will. He had no business writing his own will. It was me, and so I think I took $50 from him. I'm sorry, does that get me kicked out of Q Law?
No. So what we're saying is that it just, then you're covered under your own malpractice then. If you wrote the will out to yourself, I'm just kidding.
Yeah, no, it's okay. It's okay. But thank you. I don't. It was just one of those weird situations.
Yeah.
And I don't want anyone thinking I'm going there to drum up clients.
Well, and I also think we shouldn't find it that surprising if people do try to follow up with us, because people have so few legal resources. There is an absolute dearth of representation for anybody who's not, frankly, a major corporation or not like independently wealthy, but at least of somewhat of means in this state, let alone country. So someone reaching out to you may happen, and just knowing what the rules are, what you want to do, and then maybe where to direct them in terms of other community resources, I think is the way to go. Yeah, it's okay.
So sometimes people really need continued representation, which
Right.
is different, of course, from the limited representation
Right.
scope.
And that sometimes actually people, as was said by the mysterious woman in the back, what's your name? Sarah. We can go just first name, Sarah, it's fine. Sarah from Pierce County, VLS, was indicating that some of these cases necessitate that ongoing representation. And in some cases, people are in luck, like employment cases might be taken on contingency more than, for instance, family law cases. And so we're lucky in that way that if our community is looking at discrimination as opposed to a personal family law issue, that potentially there's that representation there for them. Anything else? This has never been such a hot topic. So glad we all had so much to say. Anything else? Anything else? Anything else? Okay, moving on. Confidentiality. I think this one is one that's really interesting and specific to our community, because I could be talking about a client of mine from the criminal law perspective who's not remotely related to my personal communities, and describe characteristics of them, even if they are really specific. you know, let's say I'm discussing a case with a colleague and wanting to be sure I've done the correct thing, and I describe this person and say, well, you know, he always wears a bright yellow suit. That might mean nothing to that person and to the vast majority of people. But let's think about our very small LGBTQ communities, and that if I were to describe someone in the audience, for instance, well, you know, I mean, she does some stand-up comedy, and she used to live in Texas, but now she's been here, and she works at Camp Tentries with me. Anybody who knows like 3 facts about Kathleen knows that I'm talking about Kathleen, right? Because we're in this very small community of people. So I think confidentiality in terms of this is even more important than it is perhaps even in our general practice settings. Not to say that it's not important there, but I guess more sensitive in terms of information that might seem benign that actually can really lead you right back to who this person is. And I don't know if anybody here is a family law practitioner, but let me tell you, the family law bar, especially the LGBTQ friendly or LGBTQ attorneys, everybody is mixing in with everyone. I mean, that is an area of great crossover. So that's what I would say initially in terms of looking at confidentiality. Overall, you shall reveal information relating to the representation of a client unless the client gives informed consent, and the disclosure is impliedly authorized in order to carry out the representation, or permitted by this paragraph. I just don't think that there's really, especially in the clinic setting, much need to reveal it, except to people who are also covered under this, which is all of your clinic colleagues, right? We're, for purposes of this rule in some ways, it's almost like we are a firm unto ourselves, right? Because that confidentiality covers through other volunteers, other people that we consult with for the clinic are all covered under that confidentiality. And there are rules that are specific to clinics that I'll get to towards the end. But just in terms of the confidentiality, just know that in general, we're looking at, it would be okay to discuss this with people at the clinic, which I have done, you know, popping out of a room and telling somebody who I know is a family law attorney, hey, I did these things, does that seem right? Anything you'd add? Obviously, we're there at the clinic together.
So, Quita, can I ask a question about?
Sure.
You said you needed some filler. Is that thing picking me up?
What? No, I'm going to repeat whatever question you asked. You just asked the question concisely, and I will repeat it immediately.
This is not specifically related to clinics, no, but I've been to a couple seminars recently, and I've heard this twice from 2 different people who are taking a very rigid interpretation of this. Now, it's not my understanding that I can go to home or a cocktail party and say I had a very interesting issue today and speak.
I'm going to repeat a little bit of what you said thus far because the camera's not picking up. So if you go to, it's been your understanding that if you go to a cocktail party or home that you can mention, oh, I had this really interesting legal issue come up today. Go ahead.
But I don't mention anything. I don't talk about yellow suits. I don't.
Right, no specific details are mentioned.
The age. The people I've talked to said I tend to do that. So here I've been breaking this rule now for years. I'm sorry I have. I do talk about my work in front of other people. But it says, shall not reveal information, period. Not information that you couch hypotheticals. This is not okay to reveal information if you do not give any hints or disclose who it might be. But I can't even go home and tell people I wrote a will today for someone.
Right.
I've heard it twice now. I've not heard it in all my years of practice before. Is this some new trend? Or is it just, I've just happened to, by coincidence, hear 2 people who prefer to interpret this rule very rigidly?
I have heard it interpreted very rigidly, that you shall not reveal anything that you learn in the course of representation. And so, for instance, I, as a criminal defense attorney, learn a lot of things in the course of representation that are public information. My client's name, I mean, you can search through the Washington courts for my name and find out all the people that I represent, right? Still, I think the indication there is that I shouldn't be revealing anything. And I do think that's why people talk about hypothetical clients, because at the same time that confidentiality is fairly absolute, so is your requirement to be a competent practitioner and know what it is that you're doing and discuss cases. Even if, and particularly, I guess I would add, if it's outside of your firm. So when I was in public defense, we would meet once a week and discuss cases, but we're all in the same firm, so conflicts and confidentiality is imputed within the firm. The conflicts in particular. The confidentiality, now I wonder, I mean, maybe I shouldn't have been talking about my colleagues, but ostensibly the entire firm is representing that person. It does say under 1.6b subsection 4 that you may reveal information relating to the representation of a client to secure legal advice about the lawyer's compliance with these rules. And these rules are all of the rules of professional conduct. So that includes competency. So my reading of that is that I could discuss, without details that are going to be making people aware of who my client is, some details about a case in order to get somewhere or have a discussion with someone about what to do with this either a particular aspect of a case or what have you. So I think under section 4 that you may reveal that information, but again, it's a may, and it is the absolutism of section A, that you shall not reveal information, does say that that disclosure is authorized to carry out the representation or as permitted by paragraph B. We're getting so lawyerly here. And paragraph B tells you, the under 4, that you may reveal it relating to securing legal advice about your compliance with these rules. So legal advice, to me, I think sometimes people read this and think as to whether they're being ethical. I read that as all of the rules. I mean, it says these rules. And so I take that to also mean your competency in a particular area and being sure that the legal advice that you're getting is that you have ferreted out all the potential issues for this person before you confidently give them, your advice on how they should proceed. Is that sufficient of an answer?
Well, it's an answer.
It's an answer. Great. So I want to go to a few examples. A client wants to bring a friend into the consultation with the client. Is that okay? What do people think? Sarah's shaking her head, and I think you and I are going to disagree on this one, Sarah, so I want to hear your answer.
So it destroys attorney-client.
It destroys attorney-client privilege.
You just need to inform the client, and then they're totally able to make the decision themselves, but they need to be aware of, even if it's a small likelihood,
Right.
that the conversation is going on.
Yep. So that the client needs to be informed. And that's what I would agree with. So we actually do agree, but you were so shaking your head, absolutely no. This is the thing, lawyers are scary. I mean, even the most kind, I seem real nice, but I just got deep into subsection A, subsection B4 real quick, and that is really intimidating people. I mean, I'm joking, but I'm serious, right? And so people come to you, and often they're coming to the clinic with a really sensitive personal issue that happens to be legal, right? That's how people see it. They have a personal problem that actually relates to the law. It's not like they have a legal issue. That's not how people feel about their lives. So when someone's coming in with a friend, it's probably for support that they need, but it is always important to say, I have attorney-client privilege with you, and if we are talking about, let's say a family law case, and that person happens to know that that friend went to the clinic with that person, and then that person ends up being deposed. I mean, I try to give them an example that seems somewhat relevant, or I try to take one, in criminal law, I will sometimes take an example of, if there's a witness who sees this person come in and tells the prosecutor and blah, 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 blah. It is highly unlikely, but frankly, maybe in some areas like family law, maybe it's more likely. So yeah, Julie, did you have something? Yeah.
So to add on to that question,
Yeah.
if a pair come in as
A pair or parent? Pair, uh-huh.
come in as an amicable breakup,
Mm.
one person who may use that right as a client, but they both want to see the attorney and talk to the attorney. And this happened at clinic.
That is a very good question. So the question is, if a pair want to come in, so a partnered couple are coming in asking about a dissolution, and they're like, look, it's all kumbaya and love, we just got to split up. Can you advise them together? That one, I feel like, I guess, this is how I would personally feel. And then I think that gets more into conflict issues. So I think I need to look at that section, and because they probably need to sign a waiver and blah, blah, blah. However, that said, and then maybe Kathleen has a better answer, I think in the clinic setting, it is so brief a period of time that we have with them. If you maybe say to them at the beginning, okay, if you want to come in as a couple together, I'm going to only answer really general questions because you all could end up being adversarial, and that's a conflict for me as an attorney. So rather than having you sign out a whole big form, it's their first time in, they just want to know where the heck is the form online? How do we march into the courthouse? I think those and maybe even not, I maybe shouldn't, see, this is a perfect example. I shouldn't guess. I don't actually know. There's the answer. I don't actually know without flipping over to confidentiality.
I know what you're talking about. It was my case. They were the nicest, most beautiful lesbians I've ever met.
The most beautiful lesbians you've ever seen wanted to split up? What a travesty for the world.
I have no idea why they split up, but I didn't ask. But they had friendship forms, and they just needed help filling in the blank. We resolved it by saying I could represent only one.
We're doing what I suggested. I'm getting out my rules.
If you really want the other one to sit in, I mean, they were doing the form together, for heaven's sake. I guess I didn't really see any great harm. I imagine they're separated now. It was
We
probably
didn't offer to let them split and talk to attorneys separately.
yes.
You offered, okay, so probably because our poor videographer is probably slowly wringing their hands back there about this.
I remember one situation.
So the response was that, they were kind of already filling out the form together. It seemed like things were going fine. Was there something else that I missed?
We offered to let them see separate.
Oh, and that you offered to let them see separate attorneys.
Being clear, we could represent only one, and they would have to choose which one it was.
Or that they could only represent one and they had to choose which one it was. I mean, I'm just glancing right now at Rule 1.8, which is, see, this is a perfect example of what I said at the beginning. Look it up. Dominique's maybe going to give me an answer instead. Yeah.
I'll give you an answer.
Yeah.
The answer is, this comes up quite frequently in
Yeah.
multiple contexts, but you can act as a scrivener if the parties have already come to an agreement.
You can act as a scrivener if the parties have already come to an agreement. I'm just repeating for the microphone, not, yeah.
If there's a conflict, you cannot represent either party.
If there's a conflict, you can't represent either party. Now, really, they can't even give informed consent.
Because you've learned through the course of representing both of them, the purposes of being the scrivener to the agreement, confidences and secrets that would be otherwise unfair.
Because as a scrivener, you've learned confidences and secrets that are otherwise would be unfair to either party. Now, what if prior to any of this, they sign an informed consent thing that says two things, and I'm going to give from the legal clinic perspective. One, we understand that this inherently creates a conflict, and because of that, too, the clinic is going to only advise us on procedures and not any of our personal information. So, for instance, here, let me show you online where all the forms are. Let me show you how you find out what times ex parte are. To me, I don't know. Anyone? Kathleen? Yeah.
Yeah, so I sat in with one of our also very experienced attorneys, and it was a similar situation.
Yeah.
And what he did was he explained confidentiality and explained in case of conflict.
So the attorney explained confidentiality in case of conflict. Mm-hmm.
In this pairing, the men both agreed to both those things, that it would be fine and there wasn't a conflict. So they both sat in on the consult with the attorney, and the attorney just advised to basically talk to only one of them.
But the attorney advised it only talks to one of them.
The person who would make it
That's okay. So I'm not going to be disbarred.
So I do think more than we realize it's maybe a case-by-case situation, and I'll get to diminished capacity stuff in a second, but I think if you sniff out any type of sort of inequity between the parties at all, if not even sniffing out inequity, I just think it's something where we, in such a closed clinic setting don't know the scope of people's relationships. We don't know exactly what's going on. Personally, the only thing I would feel comfortable with doing is what I said before of here's where the forms are, here's what you have to fill out, here's the sort of, if you know, that any layperson can find online if you know where to look, right? So I'm going to direct you where to be able to access this for yourselves. Because we don't know if you answer a question of some type of splitting of assets that seems really benign that may be very significant for those people in some way. So I would be a little bit more conservative in that way, because I would prefer that they come, because we have the ability for them to meet with 2 attorneys, right? And so, yeah. Now, I used to feel differently about that when a couple came into me in our era of where does my marriage/domestic partnership fit, in terms of just wanting to understand the protections of their rights. And I guess maybe it's a similar issue. They were wanting to know what are the scope of our current protections, and that was general enough information that I was giving in terms of the status of their current relationship, whether they were domestically partnered, had moved from another state, needed that recognized, da-da-da-da-da. We all remember this era of, you know, same-sex couples with 3 marriages that just telling them sort of where they sit and where things lie, I didn't feel like created a conflict because they were just wanting to know the current status of their legal protections. Yeah?
So you could use the collaborative law model, grab another attorney, characterize it as a settlement conference.
Oh, you could use the collaborative law model, grab another attorney, and sort of phrase it like a settlement conference. See, look at you creative folks.
That's a good idea.
Yeah, that's a good one.
If they come back.
Yeah, Dominique.
But part of that collaborative process is that there are 2 attorneys involved. Each has an interest in representing only one client to that same matter. But the agreement is that if they can't reach a settlement because both attorneys were involved in the actual discussion of confidences and secrets, both attorneys then cannot represent either party.
So if there's follow-up, both attorneys can't represent either party.
And that's what protects the confidentiality, right? Collaborative law.
Got it.
Statutes on that will say, because there are 2, you each basically represent one, and then it does become a conflictual in this whole process. Neither attorney represents either.
Okay, so what I'm getting from that to distill down for purposes of our video is that there are statutes about collaborative law, which I do not have with me in my Washington Court Rules book, but that it sounds like there's other options, and I love this creativity. I mean, this is what a clinic environment is about, right? How do we best serve people? And that's why, and I'll get to this at the end, there are specific rules for clinic environments, because it's how do we provide this access to justice in the easiest way possible while still comporting with our ethical obligations. Any other questions? Okay. I think I sort of covered some of my examples here. My partner is friends with a clinic client. I just consulted. The client's told my partner everything about her legal matters, and my partner wants to know how the consultation went and what advice I gave. Can I tell my partner? I'm just going to roll with this in terms of timing. Absolutely not. But I think you could have that client sign a waiver or ask your partner to come next time. I mean, I think there are ways that that can happen and that you don't have to be a client in a vacuum with no support outside of your attorney. But in terms of just this scenario, no. They have to say, great, you should call her up and check in with her and see how she felt about it, or they felt about it, or he felt about it. If I don't use names and just describe circumstances, can I discuss a case with other people, other friends, other attorneys, other clinic attorneys? I do think under the rules that probably we shouldn't be discussing our matters with anybody other than other attorneys, either within your firm, right? Or specifically because you are seeking advice regarding, representing that person. It's really funny. I'm curious as to what people think about this one. I'm subpoenaed to testify about an incident regarding my client. The incident does not involve my representation of the client, but his attorney asks how I know the client. Can I answer? This actually kind of came up for me, believe it or not. Dominique's saying no. I agree. I think you can't say how you know them. However, I'm trying to find where it is. Under subsection B, so 1.6B6, which is also a good vitamin, you may reveal information relating to the representation of a client to comply with a court order. So a subpoena is an order. If you are ordered to testify, I think that's a different issue. However, in this scenario, it's an issue regarding representation or something outside the scope of representation. So I think that that is a little different in that you are not disclosing confidences of your client. It's something else and it's by an order. That said, because it is a former client potentially, and there are duties to former clients, I would say as soon as you realize this is an issue, you should be reading through that section, you should be calling and consulting with people. I know both the law schools in Western Washington, both UW and Seattle U, have ethics professors who will take calls. I called one, about a year and a half ago who'd been a professor of mine in ethics and asked if he had any pertinent case law on this topic that I had an issue on. This is our bar card. That's what I like to remind people of too. Like, it's a nice, fun academic exercise, and it's our bar card. So it is worth the due diligence to figure out the exact answer. But again, I mean, if you eventually get down to it's a court order, if you're in contempt of court, or you have to be testifying, I mean, you presumably have gone through some hoops to make sure that that's the point that you've gotten to, is that it's a court order. Dominique, yeah.
The other thing is that a subpoena compels appearance.
True.
And it does require that you provide some testimony, but it doesn't specify what. And there are provisions in CR 45 that allows you, if you have concerns about the confidentiality that might be revealed, you have two options. You can also make on your own motion a move to quash the subpoena. You can also, within 2 weeks, inform the other party that is requesting that your former client that you have been asked to give testimony that could concern revealing the secret that they were a former client, and they could move the court to quash that subpoena. And then the third.
Wait. Let me say those first. So remember your third. So this is why the law is so fun and fascinating, because here we are learning together. I already took out my rule book once. So Dominique is saying that a subpoena is in order to appear, not in order to testify, which is a good point and a good distinction. And that under CR that you cited off the top of your head for .45, that you can request on your own motion to quash the subpoena or get in contact with your former client, explain that you've been subpoenaed, and they can contact opposing party counsel and say, I want to quash the subpoena. Or, number three is
that you could appear, and then abstain from revealing that confidence, and do it in a camera reveal to the judge, and make the judge weigh in on that topic and insist. And that's probably your safest way.
Yeah, or you can indicate that you're refusing to testify and ask for an in-camera review by the judge of the potential, whatever it is that you're going to testify to, or the potential conflict, if you will.
Would it be sneaky to ask that old client to come in and discuss something totally unrelated to the issue at hand, but law-related, so that you could say that you are again representing that client?
So the question is, could you have the client come in to discuss something innocuous, so that you could say that you are still representing that client? I think you could get subpoenaed whether it's a current client or a former client. So I think going the route of addressing the issue of what are my ethical obligations and my obligations as an officer of the court to comply with court orders is maybe a more paramount question. Oh, I love your thinking out loud. You guys are the most engaged group I've had, actually. Is it something about Jesus? I mean, let's just be honest. There's no cross? Anyway, this is a lovely lectern. Maybe sometimes it's a bema. Maybe Saturdays this is a temple. Okay, anyway, this is a Saturday, so now we know the answer. Moving on. Why am I always the last speaker? Because I'm minorly entertaining and say things I shouldn't say. It's true, we're in a church. For anyone who is watching this at home lovingly at some point later on, we're in a church, so wherever your spiritual home is, we're here with you. 1.14, client with diminished capacity, might apply to me in this moment. So, when a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. I feel like that one's just saying, just be nice to everyone. I mean, it's a person who's coming and talking to you, and it doesn't, we'll get further into the rule of when it does matter how someone is presenting to you, but when a client is initially coming to you, it doesn't matter who they are, where they are, what's happening on the spectrum of their life, other than their ability to make these informed decisions with you, right? So in my representation of juvenile clients, I always start out and make it really clear with them that I'm representing them and that I don't communicate anything to their parents, and give them some of that power back that inherently we don't give to youth in this world until, boom, suddenly they're 18. So I think just coming at it that way is important. I will also say, to this extent, that I used to provide sort of a funny role in the clinic setting, which is that I've had a pretty wide range of clients, and particularly in my public defense work, who present themselves in a wide variety of different ways, some of which, frankly, appear really concerning to somebody who maybe works at a bigger firm where they don't have contact with clients at all. And it doesn't even mean that this person is necessarily has a competency issue or a diminished capacity issue, but just that when you are used to doing research and writing, it's hard to know how to, and particularly I think at some of these bigger firms where like the client is God, right? Like let them talk, to be able to figure out how to work with somebody who comes in with a legal issue that maybe is hard to ferret out, frankly, sometimes. Like what is the issue that's going on there? Is there even really an issue happening? And I will tell you, it's important to always believe people no matter what you present to them. And I will tell you an extremely brief war story, which maybe I shouldn't tell into the confidentiality now that I think about this. That's interesting. It's a hypothetical client. I thought I dreamed this last night. If I had a client, hypothetically, who smashed somebody else in the face with a brick, okay? So an assault. That person called the police. They all lived in the same, I think it was some type of low-income housing unit together, which is somewhat important later in the story. And long story short, I had to conflict out of the case for reasons not related to bricks or the client's issue at all, just straight up conflict of witnesses or what have you. And I got a call about 2 months later from a woman who lived in that apartment building. Oh, and I'm sorry, I should back up and say my client absolutely insisted that he was completely innocent. This had never happened. He didn't do it. And he was a pretty difficult client. He was a client who would call me a minimum of 100 times a day, and that's not, I mean literally 100 times a day. That's no exaggeration. I counted one time to just see if I was correct. Messages, 100 messages. So a very insistent person. 2 months later, this person called me and said, hey, I live next door to this person who's your client, and I can't see an innocent, I don't like him, and I have an anti-harassment order against him, but I can't see an innocent person be in jail. And I said, do tell me more. And it turned out that in this housing complex, not many people liked this person because he had kind of a intense personality, but also his apartment, because he'd lived there so long, was highly coveted. And so the alleged victim in this case had his girlfriend hit him in the face with a brick until he bled and then called the police and blamed it on my client. I have never not believed a client from that time forward, because the stories that seem the most improbable totally can happen. So I say that in part to take that into account when you're looking at diminished capacity, right? Because when we look at this rule under 1.14, what we're required to do is that if we reasonably believe that a client has diminished capacity, is at risk, when we reasonably believe that, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including all this list of things. So in the case of this client, he was still operating in his own interest, even though his story seemed completely improbable that he was the only one there. It's right outside his, I mean, you know, sort of all the factors that are present. he did not have diminished capacity at all, right? Just because something sounds like an improbable story does not mean someone has diminished capacity. Just because someone is rambling does not mean they have diminished capacity. Just because someone is mentally ill does not mean that they have diminished capacity. And so this is something where you may need somebody else to consult and to come in and to see what they think. In my work in criminal defense, in order to have someone declared incompetent, you have to actually go through a process where there's a psychologist who evaluates them. So it's not like, I mean, that's competency to stand trial, but here in diminished capacity, you don't have to do this in a vacuum. Because what it does say is that you can consult with individuals or entities that have the ability to take action to protect the client, and in appropriate cases, seek a guardian ad litem, conservator, or just guardian in general. Does that make sense to folks?
That was a really weird dream, Peter.
It was a weird dream I had, it's true. So let me give a couple of examples here. Client believes that he was denied entry to the Cuff. Do we all know what the Cuff is? This is a leather bar in Seattle, historically gay male, but I think not exclusively so. Denied entry to the Cuff because he believes that he was denied entry to the Cuff because he's an effeminate gay man. He adds that the Cuff bouncers don't like him because he knows many Cuff patrons use meth, and some are involved in a, quote, gay meth ring run out of a house adjoining his property. The client presents this problem in a concrete, straightforward manner, but continues to add further details, including believing that the, quote, gay meth ring may have tried to drug him or kill him, as well as others who are aware of the gay meth ring. What would you do? You're all looking at me with blank stares. You realize, like, all these examples are from my work. So give me the blank stares you want, and we can talk about how this has happened to me like 8 times. Yes, Julie?
Well, you want to determine if he felt like he was in danger right then.
That's a good question, whether he felt like he was in danger right then. So, and that's, you know, going back to whether there's a substantial risk of physical harm, which may or may not relate to diminished capacity, though. That might just be a thing you want to do for your client, is be sure that they feel safe. Anyone else?
Actually, I was just doing a CLE yesterday at the KCBA office on clients with mental disabilities, and it was urged that we, I guess validate isn't the word, but to challenge anyone. And do exactly like you said, how do you feel about it?
Yeah, so the response was that at a CLE yesterday, so
Continue to probe, find out more, and
continue to probe, validate what the person has said. Dominique, did you have anything different or further?
Well, I think the context of your representation is really important, because if it's a criminal defense context, we're talking about competency, which means you understand right from wrong.
Right.
And are you able to assist in your defense?
Right.
And that's a very low standard.
Right.
Very low standard. Most of my crackers can do that if they can talk, right? So my 5-year-old could do that.
Right.
Outside that context, if it does affect your representation and it does impair your ability to communicate with your client.
Okay, let me say some of these things. So whether it affects your ability to communicate with your client, right, so in the criminal realm, we're looking at something totally different, and there shouldn't be clinic or criminal cases in the clinic anyway, but your ability to communicate with your client, go ahead, sorry.
Sure, or if it impairs your ability to represent that client.
Impairs your ability to represent them effectively, yeah.
That's when you get into a real sticky situation where they might need additional, if you can figure it out. You can also ask more questions to find out if your representation is going to be impaired. And then also to ask for additional help for guardian ad litem.
Right.
Or other actions that you can seek to protect your client as well.
Right. So looking for other ways that you can protect your client, as Dominique was saying, and as the rule indicates. And then also, there's one thing that you said that I'm missing.
Ask additional questions.
I just ask additional questions, yeah. I mean, I think this one is interesting because what I'm sort of trying to get at here is that it kind of sounds like this person is sort of a conspiracy theorist type of person and maybe is a little bit paranoid. But again, I think you get back to the base issue. Is that impeding your ability to represent them or their ability to present to you in their own self-interest, right? That's the big thing with diminished capacity, is whether they're at substantial risk of physical, financial, or other harm unless there's action taken. And so, you know, in the clinic setting, somebody's ability to say to you, I've been discriminated against, period, but then I have this whole conspiracy theory about how it happened with the unicorns and then, like, you know, whatever else, is aside from the fact that, like, they were discriminated against, right? So other than ensuring that their potential diminished capacity, if they are perhaps having delusions, may or may not actually affect how you're representing them. If they can still communicate with you the legal issue that's happening and their interests within it. Let's see. Okay. Client comes in needing assistance filling out paperwork to compensate him from a Metro bus accident. He was a passenger and has a legitimate claim to the injuries he suffered. Client shares with you further information about his life and indicates that he is suicidal. What do you do? Anyone?
Mandatory duty to report.
Mandatory, you think there's a mandatory duty to report? If they admit that they're suicidal.
I said probe further.
Probe further. Anyone else?
That fits into Sarasota.
You think it fits into what?
The Sarasota, that you may report if there's an imminent likelihood of harm to self or others.
Yep, I'm trying to find it actually. I do think it's a may. It actually goes back to confidentiality. So it sort of is an interesting mixture between diminished capacity in terms of when you reasonably believe that the client has diminished capacity, is at risk of substantial physical, financial, or other harmless actions taken and can't adequately act in the client's own interest, you may take reasonably necessary protective action, including consulting with others. But then we look at, then go back to confidentiality under 1.6, that, well, shall reveal information relating to the representation of a client to prevent reasonably certain death or substantial bodily harm. And so I think that, I guess I would put it under shall. I used to think it was more of a may, but I think it's a shall if you're reasonably certain, right? Is this person, perhaps not being flippant, but, you know, needing somebody to talk to further and, right, ferreting out the situation of exactly what's going on? Are they feeling actively suicidal with a plan, et cetera, or are they feeling like, life kind of sucks, I have this, like, continual physical disability from this accident, what have you? So I think just being aware of some of those base issues in terms of as it relates to confidentiality and diminished capacity, while again using the smart people brains that we have to figure out what's really going on here with this person. Does that make sense for folks? Yeah. Well, and the last one I have, I think we kind of already covered, which is actually that partners come in together and want advice on dissolution, but that one clearly seems to be sort of the leader and, you know, marching forth and what have you, versus the other person appears to be sort of run over by the person. And I think we addressed that a little bit already. Okay, we only have 15 minutes, so I'm gonna, unbelievably, I've been able to talk for this long. Okay, 2.1 is maybe my favorite. It's advisor. Because I like to say we're all attorneys and counselors at law, because sometimes the best answer is not remotely legal. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. That is not your opportunity to take the pulpit bema. Is there some type of structure in other religions that people know of where anyway, you can't take this lectern and just give them, it has to relate to your client's situation, right? And I find particularly in the clinic setting, if somebody is coming in with kind of an amorphous issue that's not like, okay, you want to get a dissolution, it's family law. You're being discriminated against at work, it's employment law. I mean, there's not an immigration issue. It's like a general, like, this happened to me in the world and it sucks. That sometimes a non-legal issue is kind of the best place to start. And I have advised a couple times in the clinic at folks who feel like they've been harassed, particularly by the police. And oftentimes the best way to start is not by sending them to an attorney who's going to look at whether this is a civil rights violation, right? But starting back from there and making sure they've documented the situation that they've gone through. Is there an Office of Professional Accountability for this police department? You know, various things like that to address the situation, rather than just looking at this from, okay, you're here with me for legal advice. The legal advice is how to sue this person. There's many other ways in which to deal with many other issues. And frankly, I don't know if this comes up with you all, but friends calling me for quote unquote legal advice is often just, actually, you want to hear from a lawyer that, you know, don't approach this from a legal standpoint yet. Let me see if there's any that are.
I read this, Quita, I guess I read the rule a little bit differently. We all do criminal law, don't we? And I've actually had clients come in with heavy odor of alcohol on their breath, facing some criminal charge that was decidedly alcohol related. It is the elephant in the room.
So a client comes in, they have odor of alcohol in their breath, and they're facing a criminal charge. Okay, go ahead. So this wouldn't be in the clinic setting, just to be clear for folks, but continue. No, go ahead.
Oh, well, I guess I'm sorry. Clinic is a little bit different, isn't it? I read this, you know, I read this to say that we may discuss concerns like that. And I can even argue we do not serve our clients by ignoring the fact that he's sitting there, obviously having drunk quite heavily before
Sure.
the lawyer. There's a problem there. Am I the only one to reach this rule?
No, it says you may, in rendering advice, you may refer not only to law, but other considerations that are relevant to the client's situation. So that was my example in that. If somebody comes in and has a DUI and every time they come to court they smell like alcohol, that's relevant to their situation. If a client comes in and, trying to think of one off the top of my head, is always dressed really nicely, maybe you don't need to tell them about the sale at Target. Like, I know that's the most benign example, but I'm just trying to think of something that's like, you know, if it's relating to their situation. And I think as you get to know a client, that becomes more and more apparent as to whether it's relating to their situation or not. Does that help slightly? One example, a client's being harassed/slandered and his right to privacy has been violated by a man he went on one date with, parentheses, who posted pictures and comments of him. He likely has several complex civil claims that would take years of significant expense to adjudicate. He just wants the guy to leave him alone. Suggestions on that one? This is a clinic issue, actually. It was really interesting. I mean, my advice to this person, and I don't remember specifically because it's been many years now, but essentially was, you know, what do you want your outcome to be? I came back to him, like, what do you want from this situation? You probably could sue the crap out of him. Is that what you want to do? I mean, do you want to be involved in protracted litigation for years and years, or do you just want it to stop? And I don't remember what's that?
You get a protection order.
You get a protection order, right. I mean, that's the thing is, and so I sort of went through a tiered analysis with him of, when's the last time you heard from him? What if you ignore him for a while and then have a backup plan based on what maybe happens? Perhaps have you made it abundantly clear to him that you do not want him to contact you? Send that email, say do not contact me, because that starts a paper trail for things like getting a protection order for potential other violations. That it's not that the ultimate answer, even if there is a discrete legal answer, is not always the solution. Does that make sense? My favorite line in this, where is it? Comment 1, a client is entitled to straightforward advice expressing the lawyer's honest assessment. Legal advice often involves unpleasant facts and alternatives that a client may be disinclined to confront. I mean, sadly, frankly, I told someone in my line of work, there's never any joy. Like, there's no joy. My clients might have relief. Maybe if we get a not guilty, there's some joy, but probably it's still more relief, right? Like, unfortunately, the work that we do is often, again, people's problems that have become legal, right? And so these are issues that people are coming to us with, and aside from being kind to them and representing them the best way that we can in terms of a person sitting there, it's also absolutely fine to say to them, you know, I have clients where I won't talk with them any further until we take 3 deep breaths together, because that is what's best for that client in that moment. is for them to calm down a little bit so that they can feel like they're hearing my advice, we're actually doing something productive together, what have you. So, and I encourage you to really think about that. I think particularly as I've moved along in years of practice, I don't think that, and as I've seen other attorneys who only explain the legalese to their clients, those clients often feel like they don't understand what's going on because all they understand are the legal facts of a situation and not really holistically how this affects their lives or how to deal with the feelings that they have. Make sense? Okay, last one. I've got like 3 minutes or something. Oh no, it's not the last one, so we'll just slide over this. 6.1 pro bono public service. You have you should aspire. So again, this is the parental part of the bar. You should aspire to render at least 30 hours of pro bono public service per year. Publico service, it says. Great, you're here, you're doing it. We're moving on to the next one because we don't have time. So. My answer to it is you don't have to, but it's good for you, like kale, leafy greens, and flossing are good for you. As an advisor, I can tell you that because it affects you, you know, whatever it was, morally. Flossing is a moral issue. Okay. Nonprofit and court-annexed limited legal service programs. The main issue under this that is important for people to look at is conflict. And so I actually really strongly suggest for everybody to figure out what that means for you in your representation. So for instance, we have somebody who works for the Equal Opportunity Employment Commission. Great, somebody who knows all about employment law. No, she cannot advise at all on employment according to the guidelines of her organization. So she comes and does family law. Awesome, great. So I encourage everybody to look through this rule and have an understanding that it is, I guess for lack of a better term, slightly relaxed in terms of looking at conflicts. But again, I've heard this with a lot of family law attorneys, that this comes up a lot for them because the community is relatively small and there's a lot of intra-community referrals that you do need to be a little bit more careful. Whereas I, coming in, who kind of does the catch-all issues for people, and in my practice in criminal law, this frankly might more apply to me. Let's say somebody's a witness in a case and I had advised them at the clinic and I had no idea. We are subject to those rules of conflict, 1.7, 1.9a, and 118c, only if the lawyer knows the representation of the client involves a conflict of interest. Except those rules shall not prohibit a lawyer from providing limited legal services sufficient only to determine eligibility of a client assistance in the program to make a referral to another program. So you can initially meet with that client, and I'm sorry, I actually meant to read a different section that essentially says, I'm trying to find it now. Sorry, I left my highlighted copy at home. Discusses screening and things like that, but I do think that there's something, it's maybe in the comments, that indicates that sort of any potential minor conflict that might take you an extremely long time to ferret out is not as important as being able to provide this access to justice, because the reality is the advice that you're giving somebody in that very closed setting, absent some of these very clear conflict issues that we discussed, particularly in family law with partners coming in to talk to you together or representing that person further, it's more important that we address the absolute dearth of, not dearth would mean there's none. We're all here and that's great and I love that we're doing it, but by and large there needs to be far more legal services to adequately address the needs of the population of people in this country. And there is a lovely phrase that says that I highlighted at home, but maybe your homework will be to look that up. What's that? I'm giving you a platitude. Well, I didn't make that, I won't just make something up, but I did just paraphrase what I cannot immediately find that essentially, that does emphasize that that does emphasize that for purposes of this, when we're looking at clinic environments, again, for lack of the really specific language right now, that those conflict rules are relaxed, but what I would really urge people to do is to figure that out within the scope of your own practice. So again, within criminal law, unless it's somebody that I represent right then or a witness that I have right then, it is highly unlikely that I would ever be able to even figure out that that was somebody with whom I had a conflict until I'm sitting across from that person in a witness interview, right? And that is really different than we're talking about a family law attorney who might know in the greater community that this person that they are potentially going to be talking to might be a conflict. And so I think that's why we send out ahead of time who folks are meeting with. I think that's what Julie wanted me to say. She's nodding. So that you know that if you need to run a conflict check, you can. But if you show up and you're advising, I mean, this is where we get into, and really should go to, and maybe the next time I do this presentation, we'll add in conflicts, because I think conflicts are really interesting, and they are really different in terms of current clients, former clients, and it has to actually affect your representation of the client. So if I advise somebody on, I'm trying to think of a relatively benign issue that might come up in the clinic, but I advise somebody on a name change, right? And then they're a witness in my case 3 months down the road. That might actually not even be close to a conflict because it's not the same course of representation. And I'm a little bit spouting off here, so let's just be clear. But again, that's why, to wrap it all up here, you go back to the rules, right? So this is why we know the rules generally. I'm remembering right now, isn't there something about conflict and whether it affects the scope of your representation of that current client? Seems like I should go back and read the rule and check into it. So any other questions that folks have? I mean, that is really what I want to have the takeaway be, is that I think these rules are relatively clear. Sometimes there are situations where, again, like this issue of the person who's potentially suicidal, does that fall under diminished capacity? Does that fall under potential harm to themselves and others? I mean, is it a shall, is it a may, is it a should? Those are the things that we need to look up, and by and large, you are not going to have it be an emergency situation where you need to be advising someone immediately on something before you can actually figure out whether there's a conflict, whether there's an ethics violation of some kind. Anything else? Any questions? Anything?
Brilliant.
Brilliant, thank you. Any general affirmations of me or accolades that you want to throw my direction? I am brilliant. I'm the jewel on the tiara of the end of this day. Well then, should I bow for the, yes, we've completed the program. Thanks. Yeah.